welcome to Trust Me, It's Complicated podcast by me, John Marshall, where we discuss estate planning issues that affect Floridians, primarily those here in Central Florida. And the purpose of this podcast is to address a topic that is routinely brought up in my office that clients ask me about, or that I generally just see complete misunderstandings about. And so this podcast today is all centered on, can Medicaid take my house? And it sounds like a simple question. Let me tell you, just like everything else here in Florida, nothing simple about it. So let's start off with Medicaid planning. And let's start with the first issue, which is most people in Florida, not all, but most, come from other states. And most of the people that are approaching me wanting to ask questions about Medicaid come from, Pennsylvania, Ohio, Missouri, New York, New Jersey. Very few of these folks are coming to me as native Floridians. Now, the problem though is most of the people that I have Medicaid conversations with who are from other states, they're not coming to me until they have already started spending down most of their assets on the assumption that Florida Medicaid is just like Ohio Medicaid or Missouri Medicaid, or, even, Arizona Medicaid. Nothing could be further from the truth. Let's look at Florida Medicaid. Florida Medicaid says, yes, you qualify as an applicant if you meet certain income and asset requirements. Your income cannot be in 2026 over $2,982 a month. That's gross income. Your assets cannot be in excess of $2,000. And you hear that and you go, well, hold on, John. You just said the home as well. Well, why did I not include the house in the assets of $2,000? It's because the house is considered an exempt asset. When the state says you cannot have more than $2,000 in assets, what they mean are countable assets, bank accounts, stocks, bonds, things like that. What they are not counting as a countable asset is the homestead property. As a side note, another asset that is considered an exempt or excluded asset is a car of any value, of any make and model. Let's keep that in mind because yesterday I was getting my wife's car windows tinted, and in the tint shop sat a Ferrari. That particular model runs about $200,000 purchase price, and gorgeous car. Okay, I mean, I'm not a big Ferrari guy. I'm more of a Lamborghini guy, but that's a topic for another day. But if I needed Medicaid and I had a $200,000 Ferrari sitting in my garage, guess what? Exempt asset. If I need Medicaid and I have a $500,000 home, exempt asset. Plain and simple. But there's catches, and we need to be aware of what those catches are. Okay. Catch number one is the homestead property cannot have an equity value greater than $737,000. Now, for the vast majority of Floridians, not really an issue. Okay. In the villages, the average home is valued around $400,000. So yes, you do have properties in the villages and in Central Florida that are topping, $2 million. But we also have properties down in the, $175,000 to $200,000 range just in the villages. You get outside the villages, yeah, those numbers can be lower or higher. Okay. But at the end of the day, the average Floridian is not worried about having more than $737,000 in equity in the home. But let's say you come to me, you say, John, we may need Medicaid. Dad has a home. The home has a fair market value of $800,000. And I guess we got to sell the house because Medicaid says, nope, you can't have equity value greater than 737,000. Well, does that mean sell the house? No. How about we do a home equity line of credit and take out $100,000 in equity? Now the equity value of the home is 700,000. We have $100,000. Now that's a countable asset. All right. So now the home is $700,000 equity value, $800,000 fair market value. You have a promissory note. You have like a mortgage, a HELOC that now you have to pay, and you have $100,000. That's when the attorney goes, like myself, says, great, you have $100,000. How about we pay your daughter a caregiver agreement? How about we do this with the money? How about we do this where we take that $100,000 cash, turn it into a exempt asset, or somehow use it in a way that we get it out of your estate. So your cash assets are down at the $2,000 mark, but maybe we can get that money off to the side where we can then use that money to pay the HELOC on the home while you are getting care. And even though that HELOC gets paid off slowly, it's not going to get paid off fast enough to get the equity over $737,000. And that number is adjusted annually based upon inflation. So in January of 2027, that $737,000 equity amount is going to be different. Okay, it's going to be higher. So, hey, I now have a home worth $800,000. Guess what? $100,000 HELOC. We convert the cash that we get out of the HELOC into another non-countable asset or an exempt asset or, something along those lines. Now you still have the house. Great. Equity in excess of the cap is not an automatic sell the house. Because if you did sell the house, what do you have? $800,000 in cash, which is all accountable asset. And now our planning strategies shift completely. I've got one right now. Lady sold her home. She and her daughter said, mom needs care. Mom is going to, not be able to afford this care. She's going to sell the house. Sells the house. Goes into assisted living. Then they realize, well, this assisted living is costing us a whole lot of money and we're burning through the money fast. And now they're saying to me, hey, how do we plan for Medicaid? Well, maybe we go buy a home again. I mean, that's actually a possibility because they're sitting on almost $500,000 in cash. And yeah, I mean, we're going to blow through all of that before we can get through Medicaid. So we got to find ways to legitimately spend it down or use it. One of those options is buy a home. Now, how do you tell a good estate planning attorney from a bad one? It's not like they're, citrus trees out there that you can go, oh, this one's ripe and this one's not. You kind of have to look around. But the sad reality is there's a lot of attorneys that sell their services and they market their services on price. And there's a lot of people who value legal services on price. In other words, good legal services are the ones that cost me the least. Well, yeah, not so, because for an attorney to make good money doing low-cost plans, they pretty much have to get people in and out as quickly as possible with as little customization as possible So in other words, everyone's kind of receiving the same plans. On top of that, if there is any customization, it typically is saying to the client, what do you want? And the client says, here's what I want. And the attorney goes, okay, we'll draft that. But because they're on a time crunch, because they gotta, get things done quickly in order to make a profit, the attorney doesn't take the time to say to the client, whoa, 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 hold on. What you want may not be in your best interest or your family's best interest under Florida law. And here's why, all right? I charge a higher fee than most of my competitors, but it's because when we're designing the estate plan, we are having this conversation.